Thanks so much, Justin, for this and for everything you've done for this program. And welcome all to today's program on Judges in the Press. Today's program is the second in a three-part series on Judges in the Press. In session 1, we talked about why judges should communicate with the press. Sessions 2 and 3 will focus on how judges should do that important work. I encourage you to keep an eye on the chat. If last session is a good indicator, there'll be a lot of good things going on in that chat, and I don't want you to miss any of them. There you can find out more about Berkeley Judicial Institute, and spoiler alert, now that we have you here, we'd love to have you back. You'll find more about our stunning faculty. You'll find out more about applying for continuing legal education. Most important, there you can pose your questions and comments. We do have a spectacular faculty to lead today's session. Judge Bernice Donald is recently retired from the Sixth Circuit Court of Appeals and now is just making the world a better place for democracy. Judge Jeremy Fogel is a retired district judge from Northern District of California and is executive director of the Berkeley Judicial Institute. Charles Hall, who will moderate today's session, is a public affairs specialist at the Administrative Office of the U.S. Courts and a former reporter. Judge Marcia Krieger is a district court judge for the District of Colorado. Dan Levine is a correspondent for Reuters. We'll have an additional faculty member in Judge Trina Thompson from Northern District of California. She'll be participating by video. And I should say that all of the judges on this panel, their most recent or their current experience is federal, but they've all also served on the state bench. In developing this program, special thanks to Judge Marcia Krieger and to Charlie Hall for their devotion to this topic and for their development of a related program for federal judges earlier this year. We've happily stolen from their good work with attribution. We're also proud to have such great co-sponsors for the program: the American Judges Association, the Federal Judges Association, the Federal Magistrate Judges Association, the First Amendment Coalition, the Institute for the Advancement of the American Legal System, the Justice Speakers Institute, Media Law Resource Center, National Conference of Bankruptcy Judges, and the National Judicial College. So with all of that as background, let's get to why we're here today. Moderator Hall, where do we start, sir?
Well, first off, want to welcome everybody to today's conversation. We had a wonderful start at last week's program. And as Denise mentioned, the first program's theme was why judges should communicate with the media, and some broad overall considerations that judges have to take into consideration. This week, we're going to be focusing more on the real world experience of how this plays out, and that will involve talking with several judges as well as a reporter. And we will be doing this program in 3 distinct sections. The first one is going to involve a specific relationship between 2 of our panelists, Judge Jeremy Fogel, who was introduced a moment ago, and Dan Levine, who actually have known each other, worked together, and communicated frequently over the last 15 years. It's probably fair to say that not all judges and journalists can match their longevity and perhaps, familiarity in talking with each other, but we're giving their experience special attention because it offers examples, lessons, and even some very real world tips on how to deal with things like off the record, deadlines, and the sort for judges and journalists in a wide range of contexts. So, and then we will play a video conversation between me and U.S. District Judge Trina Thompson, focusing on ways she has communicated with reporters, especially while she was serving as a state judge in California. And then finally, we will bring in Judges Donald and Krieger, who have yet other experiences to borrow from. So we were hoping in the course of the next hour to look at this topic of how to communicate between judges and journalists from many directions. Now, at any time, members of the audience, please feel free to post questions and comments in the chat function. At the 1 hour mark, we will put some of these questions to the panel. And because I am, though a career journalist, known to blow deadlines almost with a shameless disregard, I've asked Denise Neary to give us a 5-minute warning so we can wrap up by 4 o'clock and turn it over to audience questions. So with that, I would like, if I could, to bring the attention to 2 of our panelists, Dan Levine of Reuters and Judge Fogel, now director of the Berkeley Judicial Institute. If you could each take turns, and Dan, if I could start with you, since I assume you initiated the first contact, what do you recall about how you first met, and how did your communications evolve over time?
Sure. So this was back in 2008, I think the beginning of 2008, and I had just taken over the federal courts beat at the Recorder, which is the ALM daily legal newspaper in San Francisco. And so I frankly, previous to that, had not really reached out to judges before, because most of my reporting was not solely legal focused, but the Recorder had a very, the culture there was very, very much, you should talk to judges, you should reach out to judges. It was kind of a norm there. And within the federal beat specifically, I think Judge Fogel had a reputation from previous reporters, other people in the newsroom, as someone who was, open and helpful in the past. So I sent him a note, introduced myself as kind of the new kid on the beat, and asked if he'd be up for chatting, and he agreed.
Yeah, that's pretty much what happened. Although Dan caught me with a memory lapse today. I think I said last week that I had known Dan for 25 years, and that's not quite true. So it just says something about the state of my memory. But I do remember Dan calling me and asked if we could just get together and get acquainted. And I recall we went and got coffee across the street from the San Jose courthouse, and it was really just kind of getting to know each other. We didn't talk about any specific cases or anything like that. It was like, where did you come from and what did you do? And so it was very much a get acquainted conversation. But I think one of the effects of it is that I think we both felt, I mean, I certainly did, this is somebody I can talk to. This is somebody I can have a sort of open and trusting communication with.
So how did this evolve? And either one of you can start off answering this next question. And do any particular conversations or interactions over the years really stand out in your memory?
Well, I think it probably, I think it started, I was really, a little green at the time in terms of covering the federal courts in Northern California. And so, I think it started with a lot of basics from my point of view of how the court works and how just as an institution and how judges in general approach things. But then over time, as I got more experienced and started working on more complicated and kind of advanced reporting topics, I would often check in with Judge Fogel to really gut check things and see if what I'm missing and am I understanding this right way, and how should I be thinking about it, and I think it just kind of got a little bit more it got a little bit more wide ranging and complicated in terms of the subject matter we're talking about compared to the first meetings.
Yeah, no, that's right. And it was, I think, really trying to understand each other's perspective and context. I think that, that's something that I find really valuable in the relationships I've been fortunate enough to have with journalists. It's just that, we see the world differently. I think there's a desire in both professions to get at the truth and figure out what the evidence points to and that kind of thing. But I think journalists and judges go about it differently. And I think having a better sense of what was going on in Dan's world was very helpful to me. And I think it was probably true in the other direction as well. The conversations I remember, actually, the two that stood out when I was thinking about this, both had to do with sealing of records. And so it goes to the issue of transparency. And there was a judge who Dan asked me about who wouldn't talk to reporters and sealed a lot of stuff. And he was just sort of trying to understand what was that about. And it wasn't like asking me to comment so much on whether that judge had done the right thing or not, or, whether I agreed with what that judge had done, but just trying to understand what would cause somebody to have that approach, what might be going on there, and so how might he think about it. And I think, I don't know what happened after that, other than that I think things got a little bit better. The other one I remember really pretty vividly. Dan had left ALM and was working for Reuters already, and he was doing a big story. And I don't know how much detail you want me to get into, Dan, but it was just, he really needed to understand what had happened in various court proceedings. And again, it had to do with sealing. And we talked for a long time about it, about what had gone on and what the consequences were of secrecy in that particular case. And at some point he wanted to quote me, and I said, fine, and we'll talk about those protocols in a minute. But I said, yeah, you can use this. I'm happy to have you do that. But at that time I was still an active judge, so I couldn't comment on a pending case. But it was really trying to understand, why would a judge do the kind of record sealing that had happened in that particular case? And I remember saying that one of the things that happens is that when you're a judge and you have a really busy docket, you have just a ton of cases, and cases are contentious and lawyers are fighting all the time, and the lawyers bring you a stipulation. Most of the time you're just really happy to see them agree to anything. And a lot of times if you're under the gun, you just sign the stipulation, or you don't look at it very carefully, because there's this perverse incentive almost, that you want to just, get them to yes and get the agreement on the record. And sometimes that leads to you approving things that don't serve the public interest. It may serve the interest of the lawyers and of the parties, but it doesn't really add that third eye that judges are supposed to have in a situation like that. And I remember Dan and I talked about those dynamics at quite some length. I mean, I think that phone call must have taken about an hour, as I remember it. But I think it was kind of very useful to be able to talk about, well, what was going on in the judge's situation, what's going on in your situation as a reporter. So I think that's a really memorable example to me of how you can get some synergy between our two professions.
And I think the common one of the common takeaways for me from both of those interactions, both of those conversations that Judge Fogel just recounted, the first one, he's right with that particular judge that I had asked about. Things did get better, and it was through conversations with that other judge that I realized that the reason why a lot of things were getting sealed in that case was because the judge didn't even know it was happening. It was just being done kind of automatically by the clerks or whoever. And so once it was brought to the judge's attention, things got better. And then in terms of, what Judge Fogel just described about the parties stipulating and how you've got a busy docket and you just, so they're agreeing. And so who's gonna dispute when parties actually agree on something. I think the takeaway I had from both of those is that it really helped me understand the good faith on which the judges are operating here, and that yes, maybe the outcomes, certainly from a public access point of view, can often fall short, and which I've written about a lot, but it's not because someone's actively hostile to it. It's because there are these systems that are set up in certain ways that don't produce what we would view as the right outcome or what the law actually requires. And so that helped us, I think, write about these issues in a much more precise and thoughtful way than just kind of screeching.
Yeah, the judges who were involved in that particular situation, they didn't escape criticism, but it wasn't the kind of criticism that, well, they were deliberately trying to cover up sensitive information or they were acting in bad faith. It was much more nuanced. And I think that conversation and others Dan and I have had and others I've had with other journalists, it's like you're trying to get consciousness in a judge's mind that in some of these cases, it isn't just about the parties. Litigation isn't just this binary thing, the plaintiff and the defendant or whatever. I mean, that sometimes there is public interest involved. If you have dangerous products or you have unfair business practices, or you have things that have ramifications beyond the private rights of the parties, that judges need to think about those things when they get these orders. And I don't think we're really trained that way. That's just not the way most of us tend to think. And I think so having these kinds of interactions help me develop a little more present time awareness. I need to think about that. That if somebody walks in and say, "Here's the sealing order, Judge. We worked this out. We saved you 15 hours of discovery motions. Because we agreed to all this stuff." I say that's great. But I still need to look at it and make sure that there isn't something in here that's going to raise a public interest issue.
So before we go any farther, I would like to, just the conversations you've related so far, raise questions about ground rules. How do you actually, Judge Fogel, start with you. There's certain things you've alluded to that you really aren't even allowed to talk about as a judge. And Dan, I would think from your side, there's decisions you have to make as to what am I willing to hear off the record, on the record. So can each of you talk a little bit about what you had to do in these conversations to stay within the guardrails?
I think this is really, really critical. I mean, the canons say that the judge shouldn't comment publicly about a pending matter. They don't say a judge shouldn't comment privately about a pending matter. However, I've always been really careful not to do it even in a private conversation, because I just think that the purpose of the rule really is to prevent sort of the undue influence of Judge A, commenting about what Judge B is doing. I think there's sort of a corrosive effect there. But I think the first thing I always do with a reporter when we have a conversation is say, well, okay, well, what are our ground rules here? Are we talking on background? Are we completely off the record? Is not for attribution, but you can identify a source with knowledge of the matter said such and such, or is this on the record? And usually we can get to agreement about that pretty quickly, but sometimes you can't. Sometimes the reporter really wants it to be on the record, and so then I need to decide. Well, okay, I got that. So why do they want it to be on the record? What is the reason for that? And my thinking about this has evolved, and I'm talking to reporters a lot these days about a lot of different things because I'm free to in a way that I wasn't when I was a sitting judge. And this is always the first conversation. What are our ground rules? Actually, my first question, which we'll get to in a second, is are you on deadline? But my second question is, what are the ground rules for this conversation? And the request I usually make is that can we just talk? We'll talk on background. This is not on the record. And then when we're done, if there's something I've said that you'd like to quote, then let's talk about that. And most reporters are comfortable with that. I think where they end up not being comfortable with that is if I'm the subject of the story and they're trying to get an honest reaction from me, I think letting me talk off the record is kind of like letting me be my own editor, and I don't think that they really want to do that. So I think there are situations where it's not appropriate, but I think if the idea is to educate each other and to kind of build a relationship where you're helping each other understand the world from each other's point of view, I think being able to talk on background is extremely helpful. And in the story I was alluding to earlier, Dan was gracious enough to let me do that, and we talked on background for a long time, and then we circled back, and he said, "I really would like to quote you on these three things." And I said, "Yeah, I think that's okay. There's nothing in there that's violating the code of conduct, and go ahead and use it." But that's a trust thing too. I was talking to a reporter yesterday, actually, who said, "I'm happy to abide by this protocol that you've proposed, but I don't want you saying at the end you can't use anything." And I said, "Don't worry about it. That's not going to happen." So I think we're off to a good start I hadn't worked with this reporter before, but I mean, there's kind of you got, the trust has to go both ways.
And to your point, Judge Fogel, the reason why I was amenable to that, talking on background and then figuring out what to use at the end, is because you weren't the subject of that story.
Right.
Right. And so, and I can't actually, yeah. So in terms of if I'm calling someone who's the subject of a story, I need to put things to them on the record, because the story needs to reflect that if they decline to comment, that's fine, but the story needs to reflect that we gave them a chance to. And so we can't engage really in a background type of exchange in that situation. But I would say that almost the vast majority of the conversations that I've had with judges are on what's called deep background. And the terminology gets a little bit like different people have different definitions for what they are. A lot of people, when they say off the record, actually mean deep background, and a lot of people, when they say on background, actually mean deep background. And so deep background, I think the widely accepted view of it is that if we're talking, that means that I'm not quoting this, and I'm not attributing it to like a source familiar with the matter or something like that. But nothing is stopping me from, intaking the information that I learn, and that if I get it from another independent source, then I can use it, right? And so that preserves my freedom of action as a reporter, whereas off the record technically means if I hear it, I'm agreeing not to print it, which really, I would say the only time that I ever agree to that, not just with judges, but with anybody, is if like if it's like someone's going to get hurt because a particular detail is printed, or it's like about a minor, a kid and their medical condition or something like that. So anyways, in terms of, there have been a few occasions where I've used some material on background or not for attribution, which means it's attributed to like a source familiar with the situation. And in that instance, I'll speak very, specifically about what that attribution will say. And then, yeah, sometimes it's on the record, but that's, also agreed to. Most of the time it's on deep background, which is, still very helpful for me in terms of understanding perspective and context, and having a roadmap of how to go on a certain story.
Yeah, and I think it's a very practical kind of conversation. I mean, I said earlier, even if I was off the record, I probably wouldn't comment on a pending case. And this is why, because I mean, I just don't want it to show up somewhere in some form that's going to be, somebody might trace back to me. I had a situation recently where somebody asked me about a meeting that I had attended and what had happened at that meeting. And I didn't feel comfortable talking about what had happened at the meeting. And it was all, none of this was going to be on the record, but it was even on background. I was concerned about it. And the way we worked it out was the reporter asked me, well, here's what I know. And I'm going to tell you what I have found out already independently. And all I need to know is, can you confirm that or not, And so I listened. I said, yeah, that's what happened. So when the story came out, the reporter wrote the story and said, and according to several people who were present at the meeting, this is what happened, right? All right, I was okay with that. I mean, I didn't feel like I had betrayed any confidences, and I was helping the truth get out, which I thought was the greater goal there.
And preventing errors. If the reporter had been told something about what happened at the meeting and they ran it past you and you're like, that's not right.
Yeah.
You being able to stop that reporter from making an error is a huge service.
That's right. No, that's why we had the conversation. But I think it's important to really kind of get all that stuff worked out ahead of time. I think that's one of the real benefits of knowing a reporter, as you develop a relationship. Say, okay, Dan, we're going to talk about this. So what are our ground rules? How are we gonna do this? And you can ask questions of each other and kind of get that squared away. And then you can really have a pretty honest conversation.
So I'm going to step in because this is a conversation. Honestly, I would let you guys go on for another 20 minutes, but then the rest of the panel, including me, will be angry at that result. So I'm going to keep it down to probably one or two more questions. Dan, you're calling a judge for the first time. What tips, from having done that many times over the years, would you give to another reporter who's making that call for the first time?
Yeah, I mean, so you're introducing yourself. I would say, if you've never talked to them before, I would say, I'm reaching out to you for, I'm not looking to quote you. I mean, unless you're working on a story about that person, but if you're just calling to try to get to know and develop a relationship, I would say, I'm not calling to quote you. I'm not, I don't intend to ask you about a specific case. I would just really appreciate to be able to sit down with you and learn about, your perspectives on the court or whatever issue in general. And here is my background. And by the way, here are a couple stories that I've done, and, maybe send them your best stuff, just to the stuff that's going to communicate that you're serious and careful, and that you have some experience, even just a bit, that a judge is going to look at it and say, all right, this person's been around a little bit. It doesn't have to be a lot, but you're not just sending from your high school paper or something. And I guess even better if you know someone else who knows that judge and is willing to let you use their name and say, so and so referred me. That's always great, as it is with everybody. But I think if you put those facts out there, lead with those, that I'd be curious to hear from the judge's side too, but that's how I would approach it. And that's what's been successful for me.
Dan, I unmuted.
Sorry,
I wanted to ask you,
Please.
And thank you, Charlie. And the setup that you just gave, wouldn't one of the first questions likely be from the judge, what is the purpose of the piece you're doing? Because it seems to me what the judge comments on, even though it may not be on a case, it may not be on some particular issue, the purpose for the article and the object or goal of the reporting is likely to be of interest to the judge. So would that be a piece you would cover in that introductory call?
Yeah, I mean, I think if I was reaching out not for specific story and just to develop relationships, which I think good reporters do when they're not working on a specific story, because we all always need to be talking to as many people as we can. And so in that instance, I would just say, listen, if a judge asked me that, I would say, this is not for a specific story. I'm just trying to, meet more people and understand, I want to learn what I should be writing about. Are there any issues, again, maybe not a specific case, but are there any issues that you've seen that aren't getting as much attention as they should? And, we can look at. But if I am working on a specific story, then I would absolutely be honest and say, look, I'm writing about, I'm interested in court secrecy because it seems like documents are getting sealed way, way, way too much and beyond what the law allows. And I'm trying to figure out how courts process that, and, come what may from that. I mean, maybe a judge will still be willing to engage and maybe not, but you definitely have to be honest if you're asked that.
I think so.
Judge Fogel, I want to have you think about this as you weigh in. Another judge calls you up, somebody you used to work with in the Northern District, and says, oh my God, I just got this call from Dan Levine and I'm just nervous. I don't deal with reporters much. What should I do? How would you counsel a judge in that context?
I am pretty honest with colleagues. I mean, if you want to know what my experience with X reporter is, I'll tell you. I don't know that reporter, so I can't advise you. I do know that reporter. I've had lots of good experience with them and very few bad experiences or no bad experiences. or I find this reporter to be a little bit disingenuous sometimes. It's like I will be pretty candid because I want to help my colleagues have relationships that are on solid ground. I mean, when Judge Donald was talking, I mean, so much of this, there is an intuitive part to it. It's part of getting to know someone, and you build up trust with them. If you do, that happens over time. And sometimes you talk to somebody and they just seem a little too aggressive, or they seem like they've got an agenda, and it's like, so I think if a colleague were to ask me, what do you think of X reporter? I mean, I'll tell them what my honest opinion is based on my experience.
Or similarly, what might you do to sort of set the rules of engagement? How would you walk them through that?
Well, we actually did this when I was still on the Northern District. We actually had a little session for our colleagues at the courthouse in San Francisco about the different terminology we were talking about earlier. What does it mean to do something off the record? What does it mean to do something on deep background? What are the deals that you can make with reporters at the outset? And I think even in that setting, we talked about these are the best practices. These are the ways to make sure that these relationships don't lead to unpleasant surprises. I mean, even things like boundaries. I mean, just like what is it okay to do? I know we may talk about this a little bit later, but I mean, I would say that there are a lot of reporters that I have developed very cordial relationships with over the course of my career. But if somebody becomes a social friend, then they're not going to report on my cases anymore. I mean, there's sort of one of the questions you sent in writing was, what's our relationship, Dan and I have? It's a professional relationship, but it's a very long-standing and trusting professional relationship. There's a reporter who Dan knows who asked me to do their wedding, and I was really honored, and I did. And that person has never written another story about me, and won't, because I mean, there are those kinds of boundaries you have to observe. But I think this is like relationships with anybody. You have to build trust, and you have to figure out what kind of relationship is this, and what are the appropriate boundaries.
So I'm going to call this a wrap on this first conversation. We're going to take about 6 minutes to show a video interview that I had with Judge Thompson, who can't be with us because of scheduling issues. And then we're going to open it up to the others in the panel who've waited patiently. So Justin, if I could ask you to share the video with Judge Thompson, that would be great. Hi, Judge Thompson. We're talking about the relationship between judges and journalists. But before you joined the bench, you were a defense attorney. Can you tell us a little bit about your relationship with working journalists when you were still in that capacity?
Oh, it was great. It was a mutually respectful relationship with the press. I was a brand new lawyer when I started my practice after leaving the public defender's office. But for me, the mutual mentoring was amazing. I shared the legal issues that impacted my cases and tried to educate them on the parameters for both the court and judges, and to keep the parameters in place and maintaining my role as a Sixth Amendment lawyer. And oftentimes they knew the areas in which my team was investigating. And so we'd get these great nuggets of information.
So when you became a state judge, did you continue your relationships with journalists? And if so, did the ground rules change at all because of your new role?
The ground rules changed a little bit because of my new role, but because I had maintained those friendships with the various journalists, I loved reading anything they wrote. I love good writing. So I was always abreast of some of the things that they were writing, the books they were authoring. And so having cultivated those relationships when I transitioned on to state court, I actually developed even more relationships. Dave Clark had come to the area, and he was one of our local journalists, and I would see him at community events, and that was how we cultivated that friendship. Nick Otto, who's a photographer, we both have a love for photography, and we cultivated that. Cheryl Jennings and some others, we were able to begin to do education for the bench. So when I was the presiding judge at the juvenile court, we actually hosted events called Media in the Courts.
You presided over a very high-profile case, the Ghost Ship case. Having that kind of media presence would be unnerving for a lot of judges. How did you work with reporters, and do you think your approach was beneficial to the court?
So we did staging to figure out where the press could meet predictably every day, where they would have access to those who wanted to talk to them without them clogging the egress of the courthouse or capturing images of people who didn't want to be captured on camera. So that worked out really well because I had to make sure everybody understood the Fourth Estate, the press, has access. And they are the ears and eyes for the community that can't get into those courtrooms. And so setting those parameters early were really educational. And then finally, what I did, because we had such a restriction of space that when the press could not agree on a pooling agreement, and we really couldn't discern who was who and who was authentic journalists and who were, striving to become journalists, I decided that, okay, we want the community to understand what's going on in this courtroom. There were people who had smoke inhalation. There were those who were still surviving the trauma. And we wanted the family to be respected on both sides of the aisle. So I would do short orders at the end of the day that captured all of my orders throughout the trial. That helped the journalists to get it right and accurate. It informed the public and it educated them and lifted their confidence in the integrity of what we were doing.
Judge, I want to start my last question by observing it sounds like you consider your relationships and the work you've done with journalists to be a net positive. Is it your sense that some judges may be less comfortable than you working with reporters? And do you have any advice or tips you would give to other judges?
There is a mutual trust issue. Journalists do not know all of the rules. I mean, it's like a Bible of rules that judges have to adhere to in terms of the ethical boundaries. We cannot comment on a pending or impending case. It is very easy to get seduced into giving a comment when you're in a public space and someone says, "What is that case about?" And a judge may think, or another person may think that they're giving a sound bite, but when they don't know what the case is about and they don't know where the question is coming from, they may end up doing more harm. And the judge who's presiding over the case does not want a mistrial. That is the fear of having information shared out of context. So in order to adhere to that, I think that when there's funding for a public information officer for your courthouse, that is manna from heaven.
Judge, before we wrap up, do you have any last thoughts?
My last thoughts are that continued education is the key. Access to justice is embedded in the First Amendment right to the press. They're the Fourth Estate. And likewise, these mutual relationships need to be cultivated, nurtured, and maintained. We fear what we do not understand. And with the appropriate parameters, I think that we can learn from each other and we can educate the public and maintain access to justice in a way that doesn't do any further harm. Most importantly, to all my colleagues as well as journalists, remember, we are public servants. And as public servants, it's our job to be good stewards of the community of which we have the privilege to serve. And I think if we always default to that, we can't go wrong.
Judge Thompson, thank you again so much for your time today.
Oh, it was a pleasure. And thanks for the invitation. I appreciate it.
So, Justin, thank you very much for handling the video. So, Judge Donald and Judge Krieger, first off, thank you so much for your patience in waiting. Starting, what overall reactions do each of you have to the conversations we've heard as it relates to communications between judges and journalists, and how does it relate to your own personal experiences? Judge Donald?
I was going to defer to Judge Krieger first, since I did have a comment earlier,
Okay.
then I'll comment.
Okay, very good. Judge Krieger?
Thank you, Charlie. I first want to observe that the code of conduct, at least in the federal system, does not refer to simply cases that are pending as being off limits for comments by the judges. Instead, what it says is that a judge may not make a public comment on the merits of a matter pending or impending in any court. And what the merits mean is that judges cannot comment on outcome. Was a decision correct or incorrect? Is that how the judge who is being asked would have decided the issue? Or can the judge speculate as to what is going on? And so judges cannot talk about the merits of a case. But the canon goes on to say that the prohibition on public comment on the merits does not extend to public statements made in the course of the judge's official duties or explanations of court procedures or scholarly presentations. So a fertile ground to ask a judge about a pending case, at least in the federal system, is just about procedures. What is happening? What is going to happen? What is the usual procedure? That's not a merits-based kind of comment. Now, some judges feel very uncomfortable making any comment at all about a pending matter, and that is something that we should be aware of. It's an interpretation. It keeps you on safe ground. But as judges become more familiar with a relationship with a trusted journalist, they should be able to comment, in my view, more comfortably. And that takes me to a second point. Some judges feel uncomfortable talking to any journalist for another reason. And that is because if they select or are selected by a particular journalist, there may be a suspicion that the information given by the judge to that particular journalist is not being given to all journalists. And in other words, one journalist with whom the judge has a relationship is favored over other journalists. Some judges look at impartiality as including making information available to all journalists. And so for that judge to have a comment about procedure or any other deep basis for a particular perspective, it is helpful to have some kind of public forum where all the journalists get access.
Great. Thank you so much, Judge Krieger. Judge Donald?
Yes. First of all, I commend Judge Thompson in that interview because I think she hit all the correct messages. And I can imagine that judges who handle these high profile issues are under tremendous stress because of the nature and the public interest in the case, as are the journalists. I just want to pick up on one thing that Judge Krieger said, and that is that I find many judges very uncomfortable talking to the press for a number of reasons. And some of them don't have to do with a lack of trust, but they relate to, I believe, a real concern that in the heat of the exchange, that there might be information that is misperceived by the journalist, or perhaps that the judge might misspeak, or there might be some nuance that has to be interpreted by the journalist, and there may be sort of an incorrect interpretation, and then I can't go back and change that. And when judges are commenting and they have a discrete issue on which they have commented, not a case issue, but some issue, and you're blending in a number of other voices, how is this particular perspective going to be centered? Is it going to be centered in a way that might cause misperception? So I think those are real issues. But having said that, I believe the thing that we talked about earlier, the building trust between the judges and the journalists, those concerns can be alleviated because the jurist knows that if there is a concern, the journalist is going to work to clarify that before he or she goes to press. Because they want an accurate story. They want a story that is going to educate, that is going to inform. And the other reason they want to get it right is because this is going to be an ongoing relationship. I do believe that we have a tremendous need, as I said before, to help educate the public about the law, about proceedings, by talking about the process. Now, when we are doing our jobs, there are many perceptions that perhaps are incorrect going on out there, and the journalist is not always going to have an opportunity to talk to the judge. So judges rightly say, I communicate through my written and my oral opinions. Where I'm going with that is knowing that that is the way we communicate for the most part. This other thing I'm talking about is an add-on, but it is imperative that in writing, we remember who our audience is, and we remember that journalists are going to have to get these opinions, and sometimes on fairly short deadlines, they're going to have to extrapolate what we've said, the rulings we've held, the rationale, and communicate that out to the public. So it's important for us also to be mindful when we are communicating through our written opinions, that journalists have to take that and translate it or put it in a story, and they don't have unlimited time, space, or ink to do that. So we need to also be mindful to be clear there and help the journalists do the job by our clear writing, and maybe not treating every opinion like a law review article, but treating it as an opportunity to give all of the audiences, the parties, the public, if we're on a court where our opinion will have some precedence, all of those audiences, all of those entities need to understand what we're saying, and that makes it easier for all around. So thank you.
Sure. Now I'm going to open this question up to all of the panelists who have spoken so far. I mean, clearly every judge has the option of just simply, I am not going to even pick up the phone here. I'm not going to talk to a reporter. And there are certain safeties you get from making that decision. So one thing, and started whichever order you choose to, what is the value to the court from a judge's perspective of engaging when a reporter like Dan calls or reaches out? You have the choice not to. So what goods are accomplished by saying, I will include reporters in this public education that several of you have spoken about? Feel free to start in any order.
Yeah, well, I talked about this last week. I think judges are uniquely situated to do public education about the courts. Judges have a perspective that no one else has. I mean, it's like we're sitting in the position of making the decisions, and I think we're doing our profession and we're doing the public a disservice if we don't explain what we're doing. And part of this goes to what Judge Donald just said. I mean, you want your orders to be clear, and you want to write not just for the immediate audience of the lawyers or the appellate court or whomever, but you want to try to explain in your rulings what you're doing, because maybe someone in the public is reading that ruling, or so a reporter is reporting on it. So that's part of it. But I think you can go beyond it, and you can explain, this is how the courts work. This is what, just like the example Judge Krieger gave last week, this is what an injunction is. This is what a temporary restraining order is. These are what the standards are that, and reporters a lot of times are not going to explain that. Either they don't have, it's not a priority for them, or they don't know. And a lot of times they don't know. I've been talking to a lot of people lately about financial disclosure for some reason I don't need to explain to this audience, it's actually a fairly Byzantine procedure. It's not something that's obvious, and just being able to explain, well, okay, this is how the disclosure forms work, and this is how they get vetted, and this is how they get reviewed, and this is what happens if you don't comply with the rules. And just being able to explain that, it has been so helpful, because it helps, I think, reporters don't go down the wrong path. And then I think the public gets a more accurate picture of what actually the situation is. So I really do think this quite passionately. I think judges have an affirmative duty to do what they can, as long as they don't cross over ethical lines.
I agree with that as well. I think, Jeremy, you really hit the nail on the head there, but I would add to it that there are parts of this process that no one else can address. Law school professors can't address it, and attorneys can't address it because they aren't in the courts themselves. So, for example, there are media decorum orders that are often issued in high-profile cases, and they are addressed to the balancing of particular interests, including security and whatnot. And I think that it's important for judges to explain process, because, as I said last week, when you have faith that the process is fair, you can live with the uncertainty of the outcome, and you have more confidence in the entirety of the judicial branch.
Well, I would agree with both of you, and I believe that this need and the obligation to educate the public about the law is paramount. Keep in mind, we live pretty much in a bubble. We've gone to law school. We have, many of us have worked in the courts and tried cases, and now we're the decision makers. But the vast numbers of people out there don't have that experience. And so they're getting information from a variety of sources, and they need to be able to evaluate that against something. And that's something, that standard against which they evaluate it, is going to be information that the judges provide, oftentimes through our interactions with media, but it's also going to be through our outreach in communities to talk about the law. I am amazed at, I guess, the breadth of misunderstanding, for example, about the purpose of bail. I am, and now that we have so many judge shows, people are looking at those and they're applying what they pull from there to many other situations. And so this process is something that we certainly have the ability, and I think ethically the freedom to educate around. Is something that we ought to embrace, because if the process, as you said, Judge Krieger, people perceive the process to be fair, if people understand that they can be heard in the manner in which they can be heard, and why some things can't come in, then I think people have greater respect for the process, and they have more respect for the outcome, whatever that outcome may be.
And forgive me, this is the voice of God, Moderator Hall. You asked for a 5 to 1 timing. You're there. I can't believe it. It feels like we just started.
Denise, thank you very much. Dan, what's your perspective on this? And particularly as a reporter, how valuable have these types of conversations been to you professionally?
Yeah, no, they're very valuable. And I would just pick up on something that Judge Krieger alluded to about the judges are often the only ones in the position to impart certain aspects of the process that you can't get from lawyers, you can't get from law professors. And so in terms of the journalist being exposed to that perspective, not only does it help the journalist, me, get a specific story right, or check specific facts or whatnot, but it really helps me kind of like learn, and helped me 15 years ago when I first met Judge Fogel, to kind of learn the language of the courts and learn the language that everyone speaks, which then informs my later conversations with other judges, with lawyers, and it helps me ask much better questions of other people going on, and just helps me. I mean, I think the best you can be as a journalist is when you are able to inhabit the shoes as much as possible of the subjects that you're writing about. And so, I mean, it's obviously very different, but it kind of has echoes of, there's a reason why I think law clerks are very sought after as lawyers, because they've been exposed to the internal workings of how the courts work, and they can bring that to bear on their practices later. And I think very similarly, a journalist who is able to be exposed through judges to the internal workings of how courts work brings that to bear on the stories that we do, and just really elevates the overall quality of our work.
And Dan, I can tell, and I talk to lots of reporters, and I think I can tell which ones have had that kind of seasoning and which ones haven't, because they could just can cut to the chase a lot faster. I don't have to explain everything from square one, and so I think that's really true, that as reporters develop this knowledge base, they become better at their jobs, and people are more willing to talk to them. I mean, I'll just be candid. I mean, if I'm talking to a reporter and I know that they kind of understand how stuff works, I'm going to be very candid with them. Or I'm going to be way more candid with them than somebody who's asking me something which suggests that they have no idea what they're doing. It's like it's just a big difference. And it is. I think the law clerk analogy has some truth to it.
So I'm going to ask everybody just a closing thought, but the one that's occurring to me is we're talking about channels of education. Actually, in some ways, Judge Fogel was talking about being educated by Dan, simply by the questions he was raising. Judge Krieger was talking about the importance of educating the public and really educating, and Judge Donald talking about educating the media becomes a way to educate the public. So thinking back on all the topics we've talked about, and I'm going to start right to left as it looks on my screen with you, Judge Krieger. Is there one thought you would like to leave the audience with before we open it up to questions?
I'd like to leave the audience with the idea that simply because a judge does not talk to you or feels uncomfortable does not mean that you should have suspicion about that judge. There may be some justifiable reason that the judge is reluctant at that time. And you might ask the judge if there's another time in the future that you could contact that judge.
Judge Donald?
Yes, I would say that I agree with Judge Krieger, but also I think the kind of getting to know the kind of face-to-face interaction is really important. If you don't know the judge and the judge doesn't know you, that initial call up on the phone is going to engender some suspicions and some reluctance. And so I know that we don't have the reporters in the courthouses for the most part like we used to, but if there's an opportunity to just meet the judge before you need them. When I was a bankruptcy judge, we were always told when it came to our congressional delegations, meet your congressional delegation before you need anything. And that way, whenever you do need something, they know you. So I would impart that same information. Get to know people.
Dan.
Yeah, I mean, in terms of what's been voiced by a few people here of judges, and particularly Judge Donald, judges' reticence or perhaps reticence of when they get a phone call of wanting to speak for fear of being misinterpreted or what have you. I mean, I think we've covered a few different tools that judges can use to mitigate that risk in terms of going on deep background or establishing ground rules for the conversation. But more broadly, I would just say that decision also doesn't happen in a vacuum. There are risks of not engaging as well. Then the reporter has no idea what the perspective is and how that works, which can operate to the detriment of the quality of that specific story and then stories going on. So I would encourage judges to think of it in those terms as well, that there are costs both ways, and there are tools that you can use to mitigate, the risks of engaging with someone who you don't know and who you haven't built trust with yet, to start that relationship and build that trust, and end up in a good place.
And Judge Fogel.
I really don't have anything to add to what my colleagues have said. I think they've covered it. I will put an exclamation point on what Dan said, that there is a risk of not talking to the press. Yeah. That stuff will sometimes come out wrong, and you might have been able to do something about it within the limitations of the code of conduct.
So thanks to the panel. You're going to have about 10, well, maybe 10-ish minutes to answer a few questions. And I'm going to start with the last question that arrived, because clearly we've been talking about a tension between the benefits of transparency, but very real constraints, under the codes of conduct and ethical guidelines. So we're going to go with the PhD version of this question given to us by one of our audience members. Given the issues raised in the media regarding integrity and transparency regarding the Supreme Court, how would you handle questions about that topic? Do you consider this a process question or a commentary question that judges should not comment on? That's obviously one in the news and one that puts a lot of stress on the very issues we're talking about. So would any judge like to take a crack on that?
I'm gonna jump in because I'll explode if I don't. So welcome to my life for the last 4 weeks. I mean, I've been doing a lot of conversation with the media about these issues, most of it on background. I've been quoted a few times, but most of it's been on background. And I think it's actually very, very important that the reporters who are covering this story get as much of an understanding of the architecture of the issue as they can, because otherwise it becomes very sensationalized and very political. You can just talk about, certain justices' trips and things like that. And it sort of becomes, then it's an argument about should they have done that? And, and if you like that justice, you minimize it. And if you don't like that justice, you make it into the end of civilization as we know it. And so I think trying to explain how these things work can really be helpful in helping the media contextualize and helping the public understand what's going on. And I have a bias here. I mean, I think that the problem is we don't really know what rules the Supreme Court follows because they won't tell us. And so that creates a problem, regardless of who the topic of a particular inquiry or investigation is. And so that's what I've talked about. I've talked about process. And then there were things about financial disclosures where the question is, well, are they going to investigate Justice Thomas's trip or Justice Alito's trip? And I say, well, no, actually the Financial Disclosure Committee doesn't do investigations. I mean, these are just literally basic things that reporters don't know, and they can go off kind of down the wrong pathway if they don't know it. So I think there is a place for somebody with knowledge to offer knowledge about these things. I've been very careful not to offer opinions about any particular individual because, partly that's just me and partly because I don't think it'd be helpful. But I think there's a real role for process education in an area like that, to that question specifically.
Okay. Charlie, do you mind if I ask, one participant asked about whether a relationship like Judge Fogel's and Dan and Mr. Levine's provides an unfair advantage to a particular reporter.
Dan, you want to start off with that?
Well, I mean, from the journalist perspective, I would say that you're just being a good journalist. I mean, and if you're a reporter who has the ability and the ethic and the drive to be able to establish certain kinds of relationships and open channels of information that leads to you getting that information ahead of other journalists. I mean, that's kind of what we're paid to do. So from the journalist's perspective, there's nothing wrong there.
I think there is a boundary question. I mean, I think that's maybe where this concern is coming from, and I respect the concern. I think reporters who really work to develop relationships with judges do get an advantage in the sense that the judges are more candid with them. I mean, you build the trust, you get more you get more candor. I think the judges have to be careful not to favor people just because you happen to like them, or just because, I mean, I really do like Dan. I don't mean to suggest otherwise, but I mean, I would not give him an advantage because, we have known each other a long time and we have a good relationship. I wouldn't say, well, I'm going to give Dan a scoop, that I wouldn't give somebody else, or that I would expect him not to do a story about me that wasn't totally flattering. And I think, you sort of have to watch that, and you can have relationships with people where they kind of start to cross those boundaries and they veer over into something else. I have actually done 2 weddings of reporters over the course of my career, and neither of them will ever write a story about me again. I mean, it's sort of remembering that those boundaries are important for the reasons that the question suggests. I think you have to be very careful about them.
One of the ways that judges get around that problem is to set up a court committee that includes a number of journalists and use the court committee with judges on it to convey information without favoring one particular reporter over another.
I just wanted to comment on the question that Denise posed, and that is, does it give, in the example of Jeremy and Dan, does it give Dan an unfair advantage? And I looked at the question from the standpoint that if Dan and Jeremy have a relationship, it's not that Jeremy is going to go and give Dan specific information, but is he going to take a call from Dan more readily than he would from some reporter whom he doesn't know? And I think that's what it gets at, to not that you're going to give Dan some information that you wouldn't give somebody else, but does taking the call from Dan automatically give Dan an advantage? And I hear you saying no.
Nope.
I think
I would take a call from any reporter, Bernice. I mean, okay. And they're I assume people's good faith always. I mean, and if something happens that causes me to think otherwise, well, that happens. But no, I think what the implication in the question is an absolutely fair one. You don't want to favor people that you have cordial relationships with just because of that. I mean, you have to remember that you have a public responsibility, and that's to everybody.
Okay. And that's the clarification I wanted you to make.
And I guess from a journalist perspective, the advantage tends to be temporary. Dan might get his story out first, but then it becomes public knowledge for other reporters to, follow up on. So the beneficiary is the public. They're the ones learning about it. So we are really at last questions. Denise, is there any one last question that leaps off the page for you that we might pose?
Is there any education or communications from the ethics committee about the distinction between what judges can comment about and what they can't? And if there's not, might that be helpful?
Yes, there is. Charlie and I have been involved in education preceding high-profile trials. And before engaging in that endeavor, I consulted the conduct committee in the federal judiciary to find out whether there was some problem in providing procedural information, not substantive information, not information about the anticipated merits, but instead procedural information about the upcoming trial. I received what is called an informal opinion from the Code of Conduct Council saying it was fine. And it reassured us that in presenting the procedural information, we were on safe ground.
And if I may add, because I'm part of the same initiative that Judge Krieger is speaking about, I think honestly there is a real gap. I mean, if there's one thing that I think we've learned here, there's really not a ton of interaction between judges and journalists. It's still something which is done pretty much in a one-on-one basis. And so I think there's not a lot of experience with like formal educational online seminars where we're, lecturing to journalists. And so I think the one thing I would say is there are a million different codes of conduct committee. Judge Krieger and I, we both work in the federal system. So we're talking about the code of conduct committee for federal judges. Each state system, I assume, has, something parallel to that. But I think what we're going to find out as we try to move more into the realm of more, seminar type interactions between judges and journalists, something similar, actually, what we're doing right here with the Zoom program. I have a feeling the details will have to get worked out case by case, and eventually over time, if there is a belief that educating of journalists has value, which we've certainly gotten that feedback from all sides, over time, we're going to sort out how far can you go? Clearly, nobody wants to violate any kind of ethical guidelines along the way. So it's a central interest in trying to stay not just on the safe side of that, but very comfortable on the safe side of that. So we are at 4:13, which I believe, is there any last comment from anybody on our panel before we shut down?
I have a very important last comment. I am so grateful to all of you for doing this. I think it's a really important issue for judges, journalists to think about as you all serve the public. And I'm very grateful for your engagement, your interesting ideas, and hope that many, many will be back next week.
Yes. Next, I will date myself. There was a childhood program I watched that would end with same bat time, same bat channel. So next Friday at noon Pacific time, 3 p.m. Eastern time, we will do the third and final round of this. I absolutely want to thank the BJI, Berkeley Judicial Institute, for sponsoring the program. I think it's been a wonderful experience so far, and thanks to our audience for the questions, and thanks to the panelists. We look forward to reconvening next Friday.
Thanks,
With
everybody.
Batman graphics. We'll have all Batman graphics for next week. Thank you so much. Have a great weekend, everyone.
Thanks a lot. Take care.
Take care. Thank you.